Stop because I thought the same word.
Today he called me so true.
You just gotta pull a dean.
I think it's called a Pauline. I love that. I don't care how a political moment. Yeah, I've already. And or there's something so I have the knocker.
Mason. Text the group chat. Tell your chapter to get here.
You guys don't survive, that's fine.
Sounds mean, but he is.
You're a petition.
Yeah, I go out and I'm saying I can do that.
No, you would not serious. Like, are you for real? That'd be amazing. You genuinely messed it up. I'm sorry.
Oh my god.
This is the wrong sheet.
Wow, this does taste like a pop shop, but citrusy. That's crazy.
Good evening, everyone. Thank you so much for being here tonight. Welcome to the 13th annual finals round of the Monmouth College Moot Court competition. Before we begin our events tonight, I wish to offer a few words of introduction to the competition and thanks to those who have made this competition possible. Our Moot Court competition was founded over a decade ago by our very supportive alumni and friends of the college, Dan Cotter, Brad Narstadt, and Debbie Narstadt. They were joined shortly thereafter by another alumna of the college, Kate Cross. These four individuals have supported the Moot Court program both financially and through volunteering to serve as judges in the preliminary round of our oral arguments competition and legal brief writing competition. This year, we were fortunate to have Hadley Smith-Heisler, another alumna of the college, participate as a judge in our preliminary round on Saturday. Without them, this program would not be possible. We are also grateful for our judges who will be presiding over the case this evening. Serving as our Chief Justice is Heidi Benson, a circuit judge from the 9th Judicial Circuit of Illinois. She will be joined on the panel by Justice Sarah Billington of Howard and Howard Attorneys, and Mary Corrigan, also of Howard and Howard, and a 1982 graduate of Monmouth College. All of us are indebted to a number of individuals who help ensure that this program runs smoothly. While I am unable to name everyone, Marnie Steach of the Wackerly Center for Career Leadership and Fellowships deserves special commendation for her many years of hard work in building the Moot Court program. I would also like to thank the Communications and Marketing Office for making the live stream and pictures of tonight's event possible. Finally, I'm grateful to the students who choose to take part in this competition. We had 13 students who participated in the preliminary oral arguments round this past week, of whom 4 advanced to the competition this evening. We also had 6 students participate in our legal brief writing competition, the winners of which will be announced along with the winner of the oral arguments competition tonight. A few procedural notes. During the competition tonight, we ask you to hold your applause until the end of the competition. If you have not done so, please silence any phones or electronic devices as well. I will shortly introduce the case and our competitors, and then use the traditional cry of the United States Supreme Court to begin the competition. The case before us this evening is Fred Perry et al. V. Donald Budge et al. Based on a 2007 case Heinrichs v. Bosma of the 7th Circuit Court of Appeals and the 2014 Supreme Court case Town of Greece v. Galloway. This case involves the constitutionality of beginning a legislative session with a prayer. The counselors will also argue the question of whether taxpayers have standing to bring an Establishment Clause suit against the state for this practice. The petitioners are representing Donald Budge, the Speaker of the House of the fictitious state of Independence. This argument will be presented by Luis Castillo and Dean Duncan. The respondents are representing Fred Perry and other taxpayers from the state of Independence. This argument will be presented by Carly Strom and Shannon Smith. Please rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. You may be seated. Counsel, why don't you introduce yourselves for the record?
Good afternoon. My name is Luis Castillo, and I'll be representing Petitioner 1.
Okay.
Good afternoon, my name is Dean Duncan, and I'll be representing Petitioner 2 in this case.
Good evening. My name is Carly Shaw. I'm first counsel for the respondent.
Good evening, my name is Shannon Smith and I'm responding to this.
All right. You may begin.
May it please the court, my name is Luis Castillo, and I represent the petitioner in this appeal. At this time, I would like to reserve 2 minutes of my time for rebuttal. This case challenges the proprietary of prayers in the independent House of Representatives involving 2 constitutional questions, the Establishment Clause and legal standing of this exact prayer. Under the Establishment Clause, plaintiffs all have standing as taxpayers, however, they lack consistency within their goals. They are worried about the effect of this prayer and not necessarily the expense of exact prayers. None of the plaintiffs currently have standing due to the Establishment Clause according to Article 3, as they cannot prove direct injury that has been causally related to sectarian prayer and any other marginal costs that are associated within this act. To establish standing, the plaintiffs must prove three things that has caused direct injury. Number one, they must be concrete and actual injury and not a hypothetical injury. They must have causal relationship between injury and the conduct they complained on, and they must be likely that the injury will be redressed by a favorable decision. In this case, the plaintiffs are not complaining about opening up with a prayer. The plaintiffs are arguing on the sectarian prayers in nature. That also comes into relationship of marginal costs. With marginal costs, there is no good faith pocketbook action because they are not saving money. The goal of this case is to get rid of sectarian prayers but remain prayers within the court. Therefore, they're still paying for all necessary needs for all the prayers that is currently being brought up to court. The marginal costs also associated with sectarian prayer just does not simply only on the practice of speech and anything within that sort. According to President Dormius B. Board of Education, this returns to this idea of marginal costs, that they must show a good faith pocketbook action and have direct dollars and cents injury. This had standing because they were eliminating all forms of readings of the Old Testament within this specific practice. However, in the case that we are currently seeing today, they are not trying to eliminate all prayers being brought today. They are trying to only eliminate sectarian prayers. Therefore, there is no marginal cost being infringed upon. When we return to Marsh v. Chambers, this then begins to look at this idea of the Establishment Clause and the prayers being held in court. There has always been a long history of sectarian prayers opening up court. They have always began ever since before the American Revolution and has continued on today. Getting rid of all legislative prayers will not remove, once again, not remove any marginal cost. When we look in the eyes of the Establishment Clause and this idea of sectarian prayers, they tend to argue that it is on the basis of the mention of Jesus Christ. However, when you take into consideration that you have the opportunity to fill out any form to provide in order to bring in anyone who identifies within your religion, you have the opportunity to bring in a rabbi, you have the opportunity to bring in one of the Catholic faith, the Hindu faith, any of other sorts of faiths. And when they bring in and present their prayers during these cases, they will tend to mention their God in the presence of their language. In the form of Islam, they will tend to refer to Allah. As said in the court document, they have had multiple cases in which they had talked about Hebrew, and they used the phrase tetragrammatron, and as well as Hinduism, they will refer to Brahman. Because of these opportunities to represent gods of their specific religions, one can also be thinking that the government is also representing those within those faiths. Lastly, the opportunity for the exact respondents is they have the opportunity to leave the case at any point in time and to not to feel as if they are getting coerced and under any frame of mind. The purpose of the prayers is to open up the legislation and is not to coerce the actual evidence that is being brought to today. Because of that, they allow people of the court to have the ability to leave the courtroom, and they don't have the ability to listen in onto many of the prayers being said. Within the evidence, the respondents were not able to recall a lot of the information, therefore that evidence of coercion does not really put into place.
Counsel, could you please address one of the parties, Fred Perry? Doesn't he have a special situation here?
His special situation is that he does not feel comfortable listening to the prayers inside. So within that, the court has granted everyone's approval if they do not feel comfortable the ability to leave the chambers. They have the ability to leave and therefore not hear the prayers. This opportunity is granted to everyone, But in addition, if they choose to want to have their prayers be read before the actual case, they have the ability to fill out a form that allows them to call in the specific person that's responsible for prayers to be there.
Hasn't he experienced more though? He's had to step aside as a lobbyist, has he not?
He has been able to step aside as a lobbyist, but once again, this is only during the time in which the prayer is actually going on. He still has every opportunity to return back to the chambers and listen to what is going on to the court at hand. Once again, looking back at the evidence, this idea that it is trying to coerce the people into listening to the prayers, and that's how it leads the argument. The fact that the respondent is not able to recall much of the information that was being presented within the prayer shows that there was a lack of coercion within the actual prayer itself.
Well, counsel, I mean, should it really be on a person to leave? It seems like it's state sponsorship of a sectarian prayer. Why should someone have to leave? Wouldn't the solution just be to get rid of any reference to God in the prayer, or to Allah, or any other entity like that?
That is true, but that is not the argument that is currently being presented to the court. The argument is sectarian prayers, and the fact that they want to rid of only sectarian prayers goes against their ability to even sue the court to begin with, because there's no marginal cost being infringed upon. Once again, every religion has the opportunity to be represented. It's not necessarily that they are perfectly trying to coerce people or say that our government represents a specific religion. Just a mention of God in itself is not sectarian. However, people were to perceive that as the prayer goes on is obviously subjective to all. It's not an objective statement within the prayers itself.
So you say that they don't have seating because of marginal costs. At what point would it no longer be a marginal cost to the taxpayers? Like where do you draw the line?
If it's going to be marginal cost to the taxpayers, that would require for them to be rid of all prayers being presented. But this would also come into this idea that the entirety of our history was completely wrong because we have consistently always used prayers. This also takes into question of the Pledge of Allegiance itself, which is also used in the beginning of every court case, which mentions under God, which is also another reference to this case. We respectfully request that this court reverse the Court of Appeals decision. Thank you.
May it please the court, my name is Dean Duncan, and I represent the petitioner in this appeal. At this time, I would like to reserve 1 minute for rebuttal. The Independence House of Representatives has a long history of starting each session with a prayer in order to solemnize the legislative meeting. These prayers are commonplace throughout the United States and date back to even before the American Revolution. The current practice of sectarian prayer is not in violation of the Establishment Clause. In Marsh v. Chambers, they upheld that legislative prayer had become woven into the fabric of our society and was only unconstitutional if the prayer was exploitive, proselytized a certain faith, or advanced or disparaged a certain faith. And these prayers are not doing that. They're not saying convert to Christianity, or do not be Muslim, or do not be Hindu, or do not be Jewish. All they are people coming in and speaking about their faith. Murray v. Buchanan and Newdow v. Eakins both said that Marsh allowed prayers specifically mentioning Jesus. And these prayers do mention Jesus a lot, but these prayers are allowed. Just because they're mentioning Jesus does not mean that the government is making them say that. It does not mean that the government is supporting them saying that. These people are coming in of their own free will and talking about their religions, which is allowed. If a Jewish person were to come in and talk about Yahweh or whatever their similar prophet is, it wouldn't be any different than a Christian person coming in and talking about Jesus. And to comb through all of these prayers and go word by word and try and find specific mentions of religions, deities, and prophets would be judicial overreach. And it would also violate those people's First Amendment rights. And it might even violate the Establishment Clause, because it would be the government picking through each specific prayer and trying to remove the religious aspects of that. The County of Allegheny v. ACLU in 1986 does not forbid sectarian language in prayers. So once again, these prayers, which are sectarian in nature, are allowed. The courts should care more about the broader context of these prayers and the place they take and where they take place in. In the United States, free practice is allowed. Everyone is allowed to do whatever religion they believe in. They're not required to believe in a certain faith. They're not oppressing Muslims and Jewish people and prioritizing Christians. They're not oppressing Christians. The broader circumstances of these prayers are not saying that the government prioritizes Christians. The Snyder v. Murray also said that all prayers are allowed except those that aggressively advocate a specific religion or derogates another. Once again, these prayers are not doing that. They're not saying you need to be Christian or Christianity's the best or don't be Muslim, they're bad. They're not saying that. All they are people coming in and speaking their mind about their religion. This practice has case precedent. There are multiple cases, other than the 5 I mentioned, that talk about how this is a part of American society and that it should be allowed. I would like to once again repeat that this practice does not violate the Establishment Clause or the First Amendment, which is what a hypothetical from the other side would argue. We respectfully request that this court reverse the Court of Appeals decision. Thank you.
May it please the court, my name is Carly Strom, first counsel for the respondent, Fred Perry. This case is about the Independent House of Representatives' violation of the Establishment Clause with the use of sectarian legislative prayers, and that, as taxpayers, plaintiffs do have standing to bring forth an Establishment Clause violation suit. The vast majority of these prayers are sectarian, Christian in orientation, which is exactly what our clients oppose that their tax dollars be spent on. To go into the details of the amount of money, 54 cents is spent for a form letter inviting the minister of the day, 68 cents per photo of the cleric, $1.60 for mailing of a photo protected card, or 54 cents for a thank you letter, and then $1.88 per minute of recording of the web stream for the legislative. The prayers can be heard in chamber, on the loudspeaker outside of chamber, or on the webcast as well, with no choice for anyone within the legislature to hear the prayer, creating a special burden for them. This court should affirm the lower court and hold that the respondents, as taxpayers and independents, do have standing in this case for 2 reasons. Even small tax costs are consequential, and the plaintiff, Fred Perry, has taken on special burden because of the unconstitutional use of sectarian prayers to open up the legislative sessions. In U.S. v. Hayes, under Article 3, to demonstrate legal concept of standing, one must have an injury in fact, a causal connection between the injury and the conduct that they have complained about, and a likely case that the injury will be redressed by decision of the court. Generally, one cannot allege injury solely because they are paying taxes to support a practice they oppose to. But in the Doremus case, it states that one can bring forth an Establishment Clause violation suit. The Establishment Clause is special and a unique case in the fact that people as taxpayers can sue the government for how they use their tax dollars. And the petitioners do argue in fact that this is not a good faith pocketbook action, not a direct dollars and cents injury, but it in fact is. There's direct dollars and cents being used from taxpayer money that they object to. This is also further said in Flass v. Cohen, which also says taxpayers have standing because they paid their tax money for this purpose, which they as taxpayers oppose it to be used for. Furthermore, in Doe v. Duncanville Independent School District, it said that the key is to show that the tax revenues are being expended on the disputed practice. Again, which in this case, we see the amount of money being spent is going directly towards these sectarian prayers that the taxpayers oppose their money be spent on.
But counsel, I'm sorry, go ahead. Wouldn't these amounts be expended anyway? I mean, even if you have someone saying a non-sectarian prayer, you're still gonna spend that same 54 cents, you're still gonna be spending the $1.88 per minute or whatever for recording. So,
Yes, Your Honor, this would go into the argument of is there a marginal cost? But under Kamek v. Wahey, it said that there's no requirement that as a taxpayer, they must demonstrate that their tax burden will be lightened by the elimination of the questioned expenditure. It's enough to show that the tax dollars are being spent on a practice that the taxpayers themselves oppose being spent on.
Well, there's a whole lot of things that taxpayers oppose their taxes being spent on. Why in this particular instance does that give standing?
In this particular case, it gives standing, Your Honor, because of the fact that it's a violation of the Establishment Clause. Again, these prayers are very sectarian in nature. Christian-oriented, and it's the fact that it comes from a governmental position. Again, as we've heard before, the government cannot sanction religion. That's what's happening here.
Well, isn't the government, if you kick out the references to Jesus Christ and our Savior and Allah, is not the government then also sanctioning religion, choosing a side?
I would argue that would not be, Your Honor, considering, again, we're talking about the sectarian nature of these, the sectarian language used within these prayers, and it's important to also establish that these people do have to be invited by the Speaker of the House. So again, the government in and of itself cannot sanction one religion over another. I know my opposing counsel has also talked about the fact that you could bring in other people of different faiths, but that also does not matter because sectarian language could still be used regardless if it's coming from a Muslim person or a Christian person.
Does it save the practice, the fact that there's a form to fill out and that no one is rejected, so that the Speaker of the House is not being a content discriminator, he is just really a traffic cop saying, you know, it's your turn?
I would argue no, Your Honor, because the Speaker of the House does advise that they do give an ecumenical prayer, which is Christian in orientation. So again, it's advancing Christian faith, in this case, over other faiths. To continue on, in US v. Scrap, it does say that it does not matter the amount of money, whether it is large or small. Again, the trifle is the basis for the standing, and the principle supplies the motivation. Taxpayers must show that they have paid taxes to the governmental entity, which in this case they have, and that the governmental entity has used those taxes on the disputed practice, which, referring back to Kamek v. Leahy, we have seen that as well. And furthermore, the respondent, Fred Perry, has had to take on special burdens because of the sectarian nature of these legislative prayers. In the Books v. City of Elkhart case, one can show standing if they demonstrate special burden to avoid an offensive display. As we have heard,
Excuse me, counsel, doesn't Mr. Perry have to go out of his way just to be offended?
no, Your Honor, I would argue no, because of the fact that that's not how the Establishment Clause works. You can't just say, don't be offended, because even as a taxpayer, he has a right to see these legislative sessions and to not listen to the sectarian nature of these prayers. He shouldn't have to endure this special burden just to be able to do his job properly, or even just to view these as a taxpayer. To continue, Perry has stepped away as a lobbyist and will not return until these sectarian prayers cease.
Well, counsel, didn't he say that he would be working as a lobbyist still during the pendency of this lawsuit if it were up to him?
Yes, he does say that, Your Honor, but the biggest part about this is that he can't fully perform his job not being in the legislative session every day. He shouldn't have to go out of his way to not be able to fully perform his job just because sectarian language is being used within these legislative prayers. And even within that, his income has been affected by this, still creating a special burden, creating a standing that does allow our clients to bring forth an Establishment Clause violation suit. It also says under Elks v. Bookhart that one can show standing if forced to come into direct and unwelcome contact with challenged religious displays in daily activity. Again, Perry cannot fully perform his job. His income has been affected. Even if he was still to go back into the legislature to do his job and to have to listen to these prayers, if he still wanted to get out of it, he would have to walk all the way outside of the building, or maybe even go into the bathroom, creating a special burden for not only him, but somebody else who then has to go out of their way to go and get him. So we're talking about a special burden for him, but possibly the other people in this case as well. There's special burden for multiple people. And as I said earlier, as a taxpayer, he does have a right to see the legislative sessions, and he has a right to not have to listen to the offensive sectarian prayers in the legislature. It is also said that in Chambers v. Marsh, in the lower court, said that the plaintiffs in this case do have standing not only because they are legislators, but because they are taxpayers as well. The Supreme Court agreed that the taxpayer's standing was present in this case. Thus, the plaintiffs have standing to bring the case to court. Even with small tax costs, they are still consequential, with no need to show marginal cost. Fred Perry has also had to take on special burdens because of the sectarian legislative prayers. For these reasons, this court should affirm the lower court and hold that the respondents do have standing to bring forth an Establishment Clause violation suit. Thank you.
Your Honor, may it please the court, my name is Shannon Smith and I represent respondents in this appeal. Today I will show that these prayers are unconstitutionally sectarian and give preference to Christianity over other religions. Even if they are historically practiced, the government cannot endorse one religion over another. The Independence House of Representatives begins each legislative session with an invocation, a prayer, which can be heard in chamber, on loudspeakers outside of the chamber, and via webcast. Those attending legislative sessions need to hear the loudspeakers to know when to re-enter the chamber. So these individuals need to listen to the loudspeaker in order to know when the prayer is over, and having to leave the building to not get offended by the prayers is a special burden. A vast majority of the prayers are clearly Christian in orientation, specifically mentioning Christian deities and ideas. It should be noted that 29 out of 45 of the recorded invocations were offered in the name of Jesus Christ. 41 out of 56 of the total invocations were directly associated with the Christian church. Even so, one person sang just a little talk with Jesus, and some legislators had to walk out in protest of the song being sung. Moreover, the language in some of the prayers has been especially sectarian in nature. For example, on April 18, 2005, Representative Federer stated, "And now, Lord, we ask it in your Son's name, who is Lord of Lords, King of Kings, Jesus Christ, who gave us the most precious gift, to die on the cross for our sins." Clearly, this language is unnecessary and can be viewed as a way to proselytize Christianity. Under the House rules, no one can enter the speaker's stand unless being directly invited to do so by the speaker. So while a Minister of the Day form can be filled out by anyone, individuals are chosen by state representatives and further must be invited to the stand to give the prayer by the speaker.
But counsel, doesn't the speaker not necessarily know what the person or what the speaker is gonna say, or, you know, what their religious affiliation is before the day of?
While they do know their religious affiliation, they do not know the exact prayer that they are going to be given. Moreover, these prayers tend to last a few minutes in length, so that would be a lot of information for the representative or cleric to give, and they do not give that information ahead of time. Moving on to my main arguments. While it is true that Marsh v. Chambers upheld legislative prayer given their unique history, the court also said that they must not proselytize or advance anyone or disparage any other faith or belief. This is occurring here, so our opposing counsel's argument stating the unique history of the legislative prayer legitimizes these prayers do not stand. Moreover, in County of Allegheny, which involved a holiday display, further articulated Marsh in saying that history cannot legitimate practices that demonstrate the government's allegiance to a particular sect or creed. Again, the government is demonstrating allegiance to Christianity here, so the history does not legitimate the prayers in this case. Moreover, the combination of the non-sectarian nature of the legislative prayer and the long-standing history of the prayers were essential in determining that the prayers in County of Allegheny were constitutional. But here, we can see that the prayers do not meet the standard, the outer boundary being that it must be non-sectarian. It would only be constitutional if the prayers were non-sectarian in nature combined with its long-standing existence and history. In the case of Wynne, the court held that Marsh had involved a non-sectarian prayer where the chaplain had affirmatively removed all references to Christ, differentiating the prayer in Marsh from the prayer in this case. The court also said that even if the prayers were not proselytizing, they were still unconstitutional if they advanced one religion over another. The court also rejected the city council's argument that the prayers were only for the benefit of the city council members, who should be of mention a majority of were in fact Christian, as the meetings were open to the citizens, and the prayers were directed not just to the council but to other matters as well.
Now, when they say the pledge, they say under God, right?
Correct, Your Honor.
And wouldn't that be offensive to atheists?
Your Honor, the Pledge of Allegiance is not in question here, Your Honor. The question is the prayers in this case.
Well, but, so under God is okay, which would suppose that there is a deity,
Yes.
but where do you draw the line? Is it because Jesus Christ is mentioned? What about Allah? Is Allah a different name for God?
Yes, Your Honor, the issue in this case is the sectarian nature of the prayers as well as the over the top, if you will, sectarian nature in language. For example, like I said in the beginning, the quote about, and now Lord, we ask it in your son's name, who is Lord of Lords, King of Kings, to die on the cross for our sins. That right there, that is unnecessary, and that is not just saying God, that is going out of your way to further expand on that and to promote and proselytize Christianity.
So God is okay, but no descriptors of God.
Yes, it could be said that. In Reuben v. City of Burbank, the court said that any reference to Jesus Christ in the invocation directly violates the Establishment Clause, even if it is not all prayers. The city argued that only 20% of the prayers specifically invoked Jesus Christ, though the court said that this still advanced a particular religion, even if it was not all prayers that mentioned a Christian deity. Still, 20% is 20%. We interpret March to mean that any legislative prayer that proselytizes or advances one religious belief or faith or disparges any other violates the Establishment Clause. The bottom line is that this isn't a numbers game. It's the content of the prayers that are namely sectarian in nature that directly violate the Establishment Clause. This wouldn't be violating the Free Exercise Clause, as petitioners claim, because individuals are free to practice their religion however they please and shouldn't be otherwise interfered with outside of the context of representing a government body and outside of the chamber. Also, a number of the invocations specifically thank Christ for his death and resurrection. Is this language not meant to advance Christianity? This goes beyond solemnizing a meeting. It is also the fact that there is an injury in question and that our clients have found offense to these prayers. There is evidence that the sectarian nature of the prayers have offended our clients, forcing them to go out of their way to not be offended, which, as my co-counsel said, is also a special burden. The sectarian prayers are being delivered at the seat of a government power in the Independence, which is directly government endorsement of religion. If the prayers here do not meet the standards set in March, which they don't, then they definitely do not pass the test of Lemon v. Kurtzman or the endorsement test. The 3 prongs of the Lemon test are as follows. The prayers need to have a secular purpose, its principal effect should neither inhibit nor advance religion, and it should not foster excessive entanglement with religion. Here, they are only sectarian in nature. There is no secular purpose. Clerics are advised to give an ecumenical prayer, which is defined by Webster's Dictionary as promoting or tending toward worldwide Christianity, unity, or cooperation. This is essentially Christian in orientation. The government is entangled with religion here, as religion and the state do overlap, since representatives and clerics giving prayers to solemnize a meeting promote Christianity while also representing the government. At the very least, the Establishment Clause should mean that the government cannot demonstrate a preference for one religion over another, as stated in the County of Allegheny, which they do here.
How is the government stating a preference for one religion over another if anyone is welcome to say a prayer? I mean, that to me doesn't make a lot of sense. You're saying they're preferring one over another just because, there's more that have mentioned, the Christian God than Allah or any other God. How is that demonstrating a preference if the government isn't the ones parsing out, who's going to speak and who isn't?
Yes, Your Honor. While they should not, yes, they shouldn't parse the language necessarily, it is the content of the prayers at question, and it is the fact that there is sectarian language being used at all. Ultimately, the government cannot sanction religion at all, as it is a violation of the Establishment Clause. Therefore, the current practices are in direct violation of the Establishment Clause, and the prayers are unconstitutional. We respectfully request that this court affirm the Court of Appeals decision. Thank you.
Rebuttal.
first like to acknowledge one of the arguments that was stated by the respondents, and was that Perry was demonstrating a special burden imposed to him by the prayers that was being represented in court. He has a right to be up there, however, obviously due to the prayers that are being given, he is then set with a special burden that is forcing him to leave. However, that is a burden that he is not only imposing on himself, that is a burden in all that he does not need to be in presence of. Every time a court is being open and is beginning to be in session, it begins with a prayer. The actual content itself that is being discussed within the court is not being held within the first 5 minutes of said discussion. Therefore, Perry has every opportunity to even show up late to the congressional hearing or any of the hearings that are being imposed, as it always begins with a prayer. Therefore, there is no special burden for him to be in the presence of the court. Once again, emphasizing the fact that Perry has not been able to recall much of the information that was being presented within the prayers also shows that there has not been a significant effect of a prayer to being used. Therefore, there was no special burden he endured by simply leaving the chambers. In addition, what was also mentioned was sectarian language being used in other religions. If we then begin to pick apart each and every religion and exactly how they will begin their prayers before the actual hearing, whether that be the religion of Judaism, whether that be Christianity, Catholicism, Hinduism, if we begin to pick apart exactly what those prayers contain, this then begins to confer into judicial overreach. The fact that the government is now going to have an emphasis on what exactly is being said within the prayer is overreaching everyone's right within their specific ability. Next, they like to talk about the marginal cost within this government. Obviously, it is put into fact on what is being the actual cost of the papers, the recordings, and all that sorts. However, because of the argument that they are stating and that they want to essentially only take out sectarian language and not necessarily the prayers itself, there is no gain in that marginal cost. So once again, we respectfully request that this court reverse the Court of Appeals decision. Thank you.
As the respondent said, they would like to remove the sectarian prayers. However, removing sectarian prayers is another way that the government would establish a specific religious belief. The removal of any prayers or talking about any kind of religion is not allowed. They cannot say, you can't be Christian, you can't be this, you have to talk about this one view of God. That's not allowed. That violates the Establishment Clause. One way or another, it also violates their First Amendment rights because they're limiting what they can say and what they can believe.
Well, how is that limiting what they can believe by saying you can't say this in this specific context?
Because you are allowed as an American citizen to talk about these things, and if they're not allowing them to talk about these things, then it establishes a religion, and it limits their ability to believe in that religion. So, as for Wynne, the difference between this case and Wynne is that Wynne only Christian prayers were allowed, and that specifically advanced the Christian faith over another, and the keyword over there is over another. In this case, every other prayer is allowed. Anybody can come in and talk about their faith. It's not just Christians. And with that, we would like to request that the respondents are overturned.
At this time, the judges will retreat to the chambers for deliberation. As they do, please enjoy some of the refreshments that we have available, and we'll be out shortly. All rise.
can be seated. I'm gonna stand at the podium and address the audience because I don't like to have that many people shoot my daggers. I'm just gonna begin with some just real general remarks that apply to everyone. The first remark I would say is don't do the other side's job for them. So don't argue their case because you might do a better job at it than they're going to do. And it is really hard to anticipate what other people are going to say. In general, we all agreed that you all were super solid on the facts of the case and super solid on the applicable law, and you knew what tests were and you explained to us how to apply them to the law. It was very clear all of you prepared a whole lot for this argument. I really appreciate that. Sometimes lawyers don't prepare that much and then kind of leaves you scratching your head, but you guys were great. So we're gonna go through and give specific pointers to each person.
I too don't like daggers.
I would echo what our Chief Justice said. I think that you all did a phenomenal job. I was on Moot Court when I was in law school, and I can't say that I did as well at the beginning of that experience as you all did tonight. So, Mr. Castillo, I'm going to address you. We felt that you were a little confused on the facts. You mentioned prayer being said in front of the court as opposed to the house, and so that was just a little bit of a slip up. I was a little concerned at first, thinking that you were going to be too quiet and we were going to have a hard time hearing you, but you really seemed to get into your stride and you did a great job. We thought that your argument was really well organized, so again, great job. I would just, one thing as far as not mentioning the other side's argument, this may not apply in your preliminary rounds, but it certainly applies when you've got a multiple judge panel. One thing that we were taught in law school and Moot Court was if you've got 3 judges, you're likely to have one judge that's gonna be in your corner, one judge that hates you and hates your argument, and then one judge in the middle, and that's the one that you have to convince. So just keep that in mind. But again, great job, all of you.
All right. So I'm gonna, we're just going in the order you argued. I'm gonna address Mr. Duncan. Mr. Duncan, you argued way too fast. If this was real court, the court reporter would not have been able to take you. The court reporters are certified up to about 225. I speak at a nice 150. I'm everybody's favorite judge because I talk so slow. You were up at 300. And they would not have been able to take that. So when you argue at the appellate court, they have your brief. So you don't need to read what you have written. You need to argue or give them fresh insight into what you've said. Now, you did make very good eye contact, and you were very confident in your presentation and in your answers. Your voice was nice and loud, etc. So you just have to slow down. In a real court case, you wouldn't have been able to continue on like that because the court reporter would have either interrupted you themselves or the judge would have had to slow you down. But that happens in court when you're reading because you're college educated, you can read super fast, but the court reporter just cannot take that fast. So.
All right, I'll echo
echo what my colleague said. You guys did an awesome job. I did not do moot court in law school, and I do not go to court in practice. I am strictly transactional. And I told them earlier, I had to do an argument my first year of law school, and it was on Zoom, and I was so nervous that I like threw up before it. And it was on Zoom, so it wasn't even like a real argument. So you guys did great, way better than I ever did in law school. I'm gonna address you, Ms. Strom. One thing that I think you could work on is eye contact and try not to read quite as much. Your argument, it made really good logical sense, I thought, and your answers to questions were spot on. You were really quick to answer, and I thought your answers really addressed the questions too, so good job.
Last but not least, Ms. Smith. Ms. Smith, you need to go down the road with the judges a little bit more when they're asking questions. It is possible that, even on the appellate level, that the judge has not read your brief. It is possible that they are horribly confused or are applying the wrong standard or got your case confused with something else. And if you shut down their questions, then you're shutting down your chance to fix what has gone wrong with them. You had very good pacing, you had very good use of the facts, and in general, just a very nice delivery. Okay, so that is the public critique. We had nothing to do with the writing competition, but we get to announce the winner of the writing competition. So if I read your name, go ahead and stand up so we can give you your due, because although I loved trial and I loved arguing in front of the appellate court when I was an attorney, I hated brief writing. And I still hate when I take something under advisement, then I've got to author a legal opinion, and then I gotta, do pinpoint sites, and I have to remember how to do it the old way and then the new way, because we changed the way the reporters are, and it's not the same, and my hat is off to you all for doing that. So in the 2023 legal brief writing competition, third place goes to Maya Dickerson. Second place goes to Cameron Shook. And first place goes to Peyton Crims. Peyton doesn't get it. Peyton's not here without a good excuse. Nobody tell him. Be like, yeah, I don't even know who won. With regard to the oral argument portion, the first place is Ms. Strom. Well done. This was great. You guys, it was, I am so glad I got the opportunity to do this. I have never been a moot court judge, although I did do moot court in law school, so thank you for that opportunity. Thank you.
Just a few closing remarks. Thanks again, everyone, for taking the time to be with us tonight. If you'd like to stick around and congratulate our contestants, please do so. If you want to grab some snacks for the road, also please do that. And thanks to our three judges. We really appreciate you giving up your time to help support our students. So let's get we will take some photos, so if the four of you could stick around, and the judges as well, we'll grab a few pictures. And again, thanks everyone, and have a great night.
You could come up too. We'll get you all in the picture.
Yeah!
party for me too. I was section 1 and just ran out of the room and threw up versus the
Good job, Taylor.